as established.
Yes, we are waiting for our one more panelist. Just for a minute, we'll start.
Hello. Hello.
Yes, sir.
I have joined.
Oh, you've joined, sir. Okay, I'm
Just
starting.
check it.
Yeah, sure.
Am I audible?
Chesta, please start.
Good morning, everyone, and welcome to the finals of the first edition of Zaiwalla and Company National Online Debate Competition, which is organized by Burnished Law Journal. I'm Chesta Tatir, editor and senior researcher at BLJ and the moderator for today. It is an absolute pleasure to host the first edition of Zaiwalla and Company National Online Debating Competition, reckoning the COVID-19 pandemic. As you're aware, the competition aims at inculcating a healthy debate culture among students and preparing them to defend what they truly believe in. The preliminary rounds of the competition were conducted yesterday. Today, on the occasion of the finals, we have with us our judges, Wasim Beg, who is a partner at L&L Partners, Mr. Vivek Narayan Sharma, who is an advocate at the Supreme Court and an ex-joint secretary of AOR Association. And lastly, but not the least, Manisha Chaudhary, the managing partner at UKCA Partners. We hope that through this platform, the partners have the competitive spirit and engage themselves in a fruitful debating session. About Burnished Law Journal, we aim to provide a number of legal journals and articles, especially about the practical updates of law. We actively invite people to share their research on contemporary issues of law so as to enable the growth and understanding of the aspects of the law to the individual in the society. Our main focus areas include topics on socio-legal, socio-economic, or any other law-related topic or social issue. Established in 1982, Zaiwalla and Company is the first law firm in the 1 square mile financial district of the City of London, started by a solicitor born outside of Europe. The practice began in shipping arbitration, working primarily for the Indian government before expanding into commercial law. The firm's diverse team of lawyers specialize in international arbitration, commercial litigation, and public international law, with sector experience in banking, oil and gas and energy, construction, shipping, company commercial and corporate crime. It has been a clientele base for not only just SMEs and private individuals all over the globe, but also companies from Fortune 500. We thank Zaiwalla and Company for being an ever-zealous sponsoring for the event. The motion for the final rounds today is my apologies. The final round motions is regarding the Aadhaar judgment and the privacy involved therein. For this competition, the rules shall be that each participant will have 5 minutes to speak and 2 minutes to rebut their opponent. The timer shall be visible on the screen as you can see right now. The winner and the runner-up shall be decided on the basis of the highest and the second highest scores individually. If the judges allow, we request to start the competition.
Yeah, please do.
Thank you. Starting the competition, we would like to invite the first pair, A1 and E2.
Afternoon, ma'am.
A1 and E2, please keep your videos on.
Yes.
A1 and A2.
A2 present, ma'am.
Could A1 please keep the video and audio on?
So let's start with A2. A1 is not present here.
Seeing the circumstances, we shall first be starting with the opposition, that is E2. You have a time of 5 minutes.
Ma'am, can you hear me?
I think she's there.
All right, somebody else is starting. So there's a
Your
discrepancy.
name is E1 right now. Could you please change it to E1?
Right, ma'am. Just a minute. I'm not being able to figure out where that happens. Just a moment.
If the judges do not mind, we will be starting with A2, while A1 can figure out the technical issue. Please bear in mind that
Is it possible to consider E1 as A1 for time being? Is it possible to consider E1 as A1 since she is not able to rename herself?
if the judges
Okay, no
are fine.
problem. So let's start. Judges will look upon that.
I think you can start with A2. That means, and then we keep the nomenclature as the same.
Yeah, right.
So that there is no confusion.
Okay, sir. Good afternoon, dignitaries and my fellow participants. I, as Speaker A2, would be opposing the motion that Aadhaar Act does not violate the right to privacy as enshrined in the Constitution of India and recognized by a 9-judge constitution bench in retired Justice K.S. Puttaswamy versus Union of India. Now, a question comes as to what is the nature of this right which is available as a right to privacy. Is it a blanket or absolute right provided in the Constitution? No. Any right in the Constitution is not available absolutely. Even right to life under Article 21 of the Constitution can be curtailed as per procedure established by law. That is due process clause. We have seen it evolving since the Menaka Gandhi versus Union of India judgment came. Furthermore, right to privacy is available only at places where it is reasonably expected to be available. One cannot claim protection under this right n number of times or at n number of places. Furthermore, the very judgment which recognizes right to privacy as a fundamental right creates exceptions also and provides reasonable restrictions to the right itself. In paragraph 311, it says, apart from national security, the state may have justifiable reasons for collection and storage of data. In a social welfare state, the government embarks upon programs which provide benefit to impoverished and marginalized sections of the society. So this is a legitimate state claim, and this cannot be denied to the state because it has to look after the country and has to provide welfare to several individuals. Furthermore, there are 4 principles given in the very judgment. In paragraph 638, for test of constitutionality when it comes to a test under the right to privacy doctrine. The 4 tests are, the first one is the action must be sanctioned by law. We know that the Aadhaar Act is sanctioned by the Aadhaar Targeted Deliveries and Subsidies Act 2016. Secondly, the proposed action must be necessary in a democratic society for a legitimate aim. To determine the legitimate aim of the legislature, we need to look upon the preamble of the act itself and the statement of objects and reasons which are the two aids of construction and interpretation. Furthermore, the extent of such interference must be proportionate to the need of such interference. So the doctrine of proportionality is also being engaged here. Fourth and the last one is there must be a procedural guarantee against abuse of such interference. This is all given in para 638 of the right to privacy judgment. Now, when we look at the Aadhaar Act itself, what does the preamble say? Preamble gives us the intent, the first test of constitutionality. It says act to provide for as a good governance, efficient, transparent, and targeted delivery of subsidies, benefits, and services to individuals residing in India through assigning of unique identity numbers to such individuals and for matters connected therewith or incidental thereto. Section 4 of the Aadhaar now, it is not a mandatory provision. It is on voluntary basis, as section 4 says that if a person fails to furnish his Aadhaar details or he has not been provided with a unique identification number, then the explanation says for the purpose of this section, voluntary use of Aadhaar number by way of authentication means the use of such Aadhaar number only with informed consent of the Aadhaar holder. Informed consent has been given weightage here, and also alternative IDs are accepted for verification. Now, under section 7, again, the provision of alternative IDs is given if somebody fails to furnish their Aadhaar details. Under section 7, certain entities are engaged by the central authority to look after the data records. And these are regulated by regulations. They cannot claim to do anything. They are well governed by law. Furthermore, chapter 6, that is section 28 to 33, provides for a mechanism of protection of information which has been generated or which has been collected for in regard to Aadhaar. So this is a protection mechanism which was also a test under the original Aadhaar original privacy verdict. Furthermore, under chapter 7, that is section 34 to 47, offenses and penalties have been provided for any breach of any obligation under the Aadhaar Act itself. Furthermore, there are appellate authorities and redressal agencies also provided in the Aadhaar Act. The appeal goes as high as to the Supreme Court of India. So this is a very balanced piece of legislation with a very pure intent. This, as held in the three-judge bench of the 2018 case amendment, it is constitutionally, and there arises absolutely no question about it being infringing the right to privacy, fundamental right. It falls within the reasonable restrictions of the right to privacy. So I rest.
Thank you, A2. We shall now be moving to A1.
Ma'am, she is not audible. She's on mute.
A1.
Am I audible now?
Yes, you are.
All right, I'm sorry. A very good morning to everybody. I shall today be submitting my responses and arguments in strong proposition to the Aadhaar card being a gross invasion of the right to privacy as envisaged under Article 21 of this Constitution. Now, my very worthy opponent mentioned a lot of points that I shall be rebutting completely and entirely in my argument right now. The Aadhaar database is, like everybody knows, is one of the largest government databases on the planet with a 12-digit unique identification code. Now, the structure of my debate and submissions shall be as follows. I will first be discussing what the discrepancies in the Act is and be rebutting what my opponent just said. The second will be how there is a lack of statutory liability of the UIDAI in the Act, which is the authority that has complete adjudicatory powers and which my worthy opponent very conveniently brushed under the carpet. The third is how non-fulfillment of doctrine of proportionality, which again my opponent mentioned but brushed under the carpet. And the fourth will be how I will relate this doctrine of proportionality to the four major privacy concerns of an Indian citizen. Now, coming to the first part, which are the discrepancies in the Act. The first is, sir, how there is a lack of clarity found in a lot of sections. Ma'am, in section 23, for example, 23 subclause 2 subclause K, which permits the Unique Identification Authority of India, which is the UIDAI, to share certain information about individuals in such manner as may be specified by regulations. This is the phrase that has been used more than 27 times in the Act, ma'am. Also, this has been used in sections like 2G, 2K, 54, subclause 2, subclause 1, etc. Now, the second point is the Aadhaar Act does not provide any opt-out clause. It does say voluntary, but it does not anywhere talk about an opt-out clause. Now, this is where an Aadhaar card holder can choose to leave the system and forego all its benefits. Also, there was another point brought up by my opponent where it said that there are other voluntary, other PAN card, etc., that can be used. However, ma'am, there is no way that this Aadhaar card, it fails to provide or prescribe data breach notification requirements. My opponent said how there are regulations, how it is secure and safe, but these are only words in a very utopian world. It nowhere comes up with a stern mechanism. Now, I will be drawing an analogy from the US system, since it's a country which has been very vocal and which has had a very successful security system. In the US social security system, there is something called the data breach notification requirements, wherein if there has been a breach, that means if information has been shared from the government to another person, there is a notification sent to the account holder, which is absolutely absent in this act, which means the privacy of me as a general citizen of this country is held so meagerly by the government of India. Now coming to the second part, ma'am, how the liability of UIDAI, which is absolutely absent in the statutory liabilities. Now, under the Aadhaar architecture, UIDAI is the only authority which comes out with all functions, be it administrative, adjudicatory, investigative, etc. The Act is absolutely silent on any liability. Under Section 23, yes, 23 subclause 2, subclause S, it does establish a grievance redressal mechanism. However, there is absolutely no mention of this grievance redressal mechanism after this, what it constitutes, who will head it, who will be presiding over it. There has been absolutely no clarity. It is not enough to only mention the name and let it be later. Now, ma'am, coming to the doctrine of proportionality, doctrine of proportionality has three major points, and this has been mentioned in paragraph 383, page number 450 of this Puttaswamy judgment. To check whether the right of privacy can be invaded or not, there have been three, it's called a three-rule formula, which is called the doctrine of proportionality. The first is that privacy can be invaded only to a permissible limit. Now, ma'am, here the concern is, I will be giving you I'll be giving you 4 privacy concerns to prove that this is not a permissible limit at all. The first privacy concern here will be, ma'am, how there are data security concerns. Sir, in Hindustan Times, it was reported that 200 students in Mumbai replicated their fingerprints on a widely used, portal to fudge biometric attendance. Now, if students can do it, anybody can. And as the Prime Minister of India tweeted about 2 years ago, your thumbprint is your bank. And this was their selling point, which is completely negated in this argument. Ma'am, is it okay if I take 30 more seconds?
It shall be at the discretion of the judges.
Sir, could I take 30 seconds more? Thank you. Thank you. Second is, sir, how there is also an ambit, a very important perspective of personal integrity and civil rights here, and not just data security. Personal integrity here, ma'am, comes on, for example, I want to take an example of Bihar. A lot of impoverished regions of Bihar have a lot of women who are suffering from cervical cancer. With Aadhaar card coming into play, my entire health history, it's like a health trial, which is enrolled in this card. There have been a lot of cases where forced sterilization has been happened. Why should something that I whisper in my room to my husband or my family go out and be spread in the streets? There is a personal integrity involved to this, and I believe that this is a complete infringement of privacy as a citizen of this country. Thank you.
Thank you, A1. We shall now move to rebuttal. You both will have 2 minutes each. Please bear in mind that you cannot ask questions to each other. A2, right, over to you.
Yeah. So, as ma'am rightly mentioned, that there is a clause under Section 23 that The authority may use data when it wants, but it also has to be read in accordance with other provisions of the Act, which say that the data so received shall not be used for any other purposes for which it has been received for and the consent has been provided for. So they cannot go beyond the concept of consent, received consent aspect. That is the first thing. The second thing is that is not sending is not sending a notification of data breach, a breach of privacy. I find it absurd, and this is not even a tangent to the point we are trying to make here with regards to being the act being unconstitutional to right to privacy as a fundamental right. Furthermore, when the redressal mechanism is concerned, it has been mentioned that there shall be a redressal mechanism which the central government is empowered to formulate by regulations at a subsequent stage. So this it is not that they have absurdly left it out of the act. They have well within provided for the central government to formulate rules and also the authority. Furthermore, Justice Bhushan in his 2018 verdict mentioned, when it comes to breach of privacy regarding Aadhaar, we also need to have a look at to what information the Aadhaar actually contains. Those information are actually natural information which every individual shares amongst the society and is naturally available to other people. So it is not a sensitive information being violated, if at all it is violated. It shouldn't be violated. It is an offense that it gets violated. But similarly, they have provided for such violations as a penal offense in the Act itself. The Chapter 7 expressly deals with it. Furthermore, she mentioned a incident wherein students created fingerprints, and this is an offense of impersonation under Section 34 of the Act. The Act provides for such problems, and it is a very vast piece of legislation encompassing other valuable things in it for the protection mechanism, for the redressal mechanism, and also for data breach. For example, the data protection law has also been a tenet of the right to privacy judgment. Now, the data protection bill is still pending. It is in the pipeline, but certain aspects are dealt expressly when data is concerned in that bill. Aadhaar deals with a very limited aspect of data. It does not connote data protection as a whole. It has the data protection has been dealt in a separate bill altogether, which shall be made a legislation if the parliament passes it. Thank you.
May I begin?
Yes, please.
Sir, you mentioned about how where there is where you talked about how there is natural this information is extremely natural, etc. I'm really sorry to say, sir, it is not natural at all. And even if it is, I refuse to accept that the population of this country is ready to give out this information to the government or to a third party. Now, I may like to bring it to your notice that you also mentioned how there are a lot of other places, other organizations already doing it. Like, you know, I will give you an example of how the Registration Act already has it, or how you already need this information like in visa. However, we have to understand that this response is extremely inadequate. It ignores that such usage comes with a lot of stringent legal restrictions. What are the legal restrictions in this act? I know you're talking about Chapter 7, Section 34, which talks about penalty, Section 34 onwards, which talks about penalties and offenses. Sir, the maximum penalty is 3 years, and the maximum punishment for your pecuniary penalty is 10,000 rupees. Do you think that's enough for a breach as grave as this? Then you talked about how there is the authority, like, right. So you said there are grievance mechanisms and there are authorities that the government can come up in a subsequent stage. So I'm really sorry to tell you that it has already been a year and a half since that judgment came out, and there has been no, and there have been, if I can tell you a few instances where there have been gross violations and there has been no government machinery or grievance mechanism that has been put into place. It's very easy to say that we've written it in the act and we will make a subsequent change, but if that hasn't come up in practice, then it is absolutely of no use, and it is as equal to making fallacies to the government. Now, there are a lot of arrangements there have been a lot of privacy concerns in also the country. For example, a few weeks ago, there were hackers who were found to use GPS systems to track Aadhaar ID cards and Aadhaar numbers. Now, sir, how do you manage this? There has been no grievance mechanism here. There has been no hierarchy of courts. There has been no hierarchy of appeal here. We can't just say that these things exist when they don't exist in practice. Thank you.
Ma'am, may I be granted time for rebuttal?
I'm sorry, but you do not have a time granted for third rebuttal.
Okay.
No, second rebuttal.
Okay. Thank you, sir.
Right, sir. Thank you.
If the judges deem it fit, we shall now be moving to the second competitive pair, B1 and B2.
Right, go ahead.
B1 and B2, please switch on your cameras and your microphones.
Yes, ma'am. Can I start, ma'am?
Yes.
Okay. Good afternoon, honorable judges and my dear co-participants. I am speaking for the motion that Aadhaar judgment was an infringement to privacy. A farmer in a village woke up one day to realize that his fingerprints were taken and a bank account was opened in his name without his consent. This, my friends, is one of the many cases that happened after the Aadhaar came into picture. Aadhaar took away details of people, sold it to large telecom companies without the consent of people, and these large telecom companies opened bank accounts in their names. If this is not a gross violation of privacy, I don't know what is. With this, I start off my debate. I would structure my debate in this way. First, I would be talking about the conception of privacy. Then I would move on to how information is being shared through Aadhaar. And thirdly, I would also draw a parallel to the international organizations and international treaties which talk about data protection. Now, talking about the conception of privacy, my mind goes back to an essay written in 1890, published in the Harvard Law Review, which speaks about the conception of privacy. Judge Collins in that essay says, privacy means the right to be left alone. My dear friends, this was published in 1890, where there was no use of technology, where there was no use of technology, and there was nothing advanced in of that nature. So when we speak about privacy as a conception, we need to understand that privacy goes beyond information. Privacy goes beyond tangible things. It permeates through all this, and it comes to a point where we realize that privacy relates to personal intimacy, privacy relates to personal information, privacy relates to personal dignity of the individuals. Now, I still remember when the Aadhaar judgment was pronounced by the Supreme Court, many advocates of the Supreme Court were very happy, and they said it is a winning of the civil liberties of the people. They said this right to privacy does not only pertain to Aadhaar, it permeates to various levels. It permeates to whether a police officer can enter and conduct investigation. So this right to privacy cannot be constrained into a concise manner. Now, moving on to this, I would speak about how information collected is being misused. When you talk about Aadhaar, a lot of us have a misconception that the information has been stored at CIDR in Manesar and Bangalore, and the firewalls can be broken. But the whole problem with this is it is not about the servers or the physical storage of the information. The point is there are three kinds of information that has been collected by Aadhaar. The first is the biometric information, the second is the identity information, and third is the personal information. Now, the biometric information such as the iris, fingerprints, and other biological aspects, and the identity information, that is the name, address, and phone number, along with other demographical aspects, finds place in the Aadhaar Act. Whereas the third kind of information, that is the personal information, finds no mention. Now, what do I mean by personal information? For example, tomorrow, let us say the government makes it mandatory for me to code my Aadhaar number while I purchase the railway ticket. I go and code my Aadhaar number to the railway and purchase my ticket. Now, in this way, IRCTC has access to my travel history. I go and purchase a SIM card tomorrow and I give my Aadhaar number. In a way, the telecom company has access to my phone number, it has access to my call history, it has access to my fingerprints, it has access to my address and everything. So this is how, my friends, personal information of a person is being leaked. It does not pertain only to biometric and identity information. Now, moving on to how privacy has been established through the courts, there have been several judgments previously which held that privacy is not a fundamental right of the citizens. However, Justice Subbarao in the Gobind case held that he was a dissenting judge and still held that privacy is a fundamental right. Uh, uh, Now, let me draw a parallel between the international organizations which talk about data privacy. My friend in A1 spoke about how the US is different, and I would like to add on to her point saying the social security number differs in many ways from the Aadhaar. First of all, there is no biometric collection of fingerprints. The second point is it does not there's no biometric collection of fingerprints. The second point is it is not published without the consent of the people. Whereas in India, there is no informed consent. My friend in A2 spoke about informed consent. My friend, I would like to tell you that when the bill was passed, it was conveniently passed off as a money bill without the consent of the Rajya Sabha. And he spoke about how the consent of the people is taken and it should be informed. I would like to also inform him that when you talk about making it mandatory and when you talk about informed consent, I don't see where these two concepts match. Now, I was very curious and I picked out a sentence from one of the telecom companies' terms and condition, which says that we understand that you accept the inherent security implications of providing info over the internet, and you will not hold us responsible for any breach of security or disclosure of personal information. Now, this, my friends, is how the devil is hidden in the details. This is terms and conditions of a telecom company, which clearly states that they will not be responsible for the disclosure of personal information that you have shared with them. In conclusion, I would like to say Aadhaar was a gross infringement of our privacy, and we need to understand that as Justice Chandrachud quoted, privacy cannot be destroyed by the vicissitudes of technology. Thank you.
Thank you, B1. B2, could you please switch on your camera and proceed?
Am I audible and clearly visible?
Yes.
Yeah, thank you. Aadhaar truly seeks to secure to the poor and deprived persons an opportunity to live their life and exercise liberty. It not only provides them a nationally recognized identity, but also attempts to ensure the delivery of benefits, services, and subsidies. Good afternoon, everyone. Today, I'm going to be speaking against the motion Aadhaar card is an infringement to right to privacy. In the Puttaswamy judgment, the Supreme Court of India clearly struck down the apprehensions regarding Aadhaar violating the right to privacy. I shall henceforth proceed to lay down the various reasons as to why Aadhaar does not violate the right to privacy by mirroring the line of argumentation followed by my opposing speaker. First and foremost, it is important to analyze the primary objective and aim behind Aadhaar. A very important feature which the present case has brought into focus rather, is another dimension of human dignity, namely in the form of common good or public good. We therefore have to keep in mind a humanistic concept of human dignity, which is based on the socio-economic rights that are read into the fundamental rights. When we read socio-economic rights into human dignity, the community approach assumes importance along with the individualistic approach to human dignity. It has now been very well established and recognized that at its core, human dignity contains three elements, namely intrinsic value, autonomy, and community value. When it comes to dignity as a community value, it emphasizes the role of the community in establishing collective goals and restrictions on individual freedom and rights on behalf of a certain idea of good life. There needs to be a balancing of two facets of dignity of the same individual. That is, on one hand, there is the right of privacy as a part of dignity, and on the other hand, a right to lead a dignified life as a part of dignity. Therefore, in a scenario where the state is coming out with a scheme which aims at giving a dignified life in harmony with human dignity, some aspect of autonomy can be sacrificed. The state is using Aadhaar as an enabler for providing deserving sections of the society the right to social assistance benefits, thereby giving their right to life to fruition. The architecture of Aadhaar, as well as the provisions of the Aadhaar Act, does not tend to create a surveillance state. This is ensured by the manner in which Aadhaar projects operate. During the enrollment process, minimal biometric data in the form of iris and fingerprints is collected. Purpose, location, details of transaction are not collected, making the process purpose blind. The information collected as aforesaid remains in silos. The merging of silos is further prohibited as well. Moreover, all matters pertaining to an individual do not qualify as being an integral part of right to privacy. Only those matters over which there would be a reasonable expectation of privacy are protected by Article 21 of the Constitution. The Aadhaar card also satisfies the triple test laid down in order to adjudge the reasonableness of the invasion to privacy. The Aadhaar scheme is backed by a statute, that is the Aadhaar Act. It also serves the legitimate state aim, which can be discerned from the introduction to the Act, as well as the statement of objects and reasons, which reflect that the Act was passed to ensure that social benefit schemes can be availed by everyone. The Aadhaar in its current form, post the judgment, is not at all violative of the right to privacy. The impugned sections have been identified and altered. For example, Section 33(1) of the Act, which deals with disclosure of information. After the Aadhaar judgment, an individual whose information is sought to be released shall be afforded an opportunity of hearing. If at all an order is passed, he shall also have the right to challenge such an order passed by approaching the higher court. During the hearing before the concerned court, the said individual can always object to the disclosure of information on accepted grounds in law, which includes privacy rights. Further, in order to avoid misuse of Section 33(2) of the Act, which mandates disclosure of information on national security grounds, the court has advised the involvement of a judicial mind for deciding cases. This again precludes the invasion of privacy. The Aadhaar and Other Laws Amendment Bill 2019 has omitted Section 57 of the Aadhaar Act, which prevented denial of services for refusing to or being unable to undergo authentication. The amendment bill also includes provisions for imprisonment up to 3 years for unauthorized use of identity information and incarceration for a period of 10 years for unauthorized access to central identities data repository. Hence, the government has incorporated the changes suggested by the Supreme Court to ensure that violation of privacy through Aadhaar does not happen. Collection of demographic and biometric data under the Aadhaar Act does not violate the fundamental right of privacy, as the information sought is limited and only for the purpose of identification. The Constitution of India does not exist for a few or minority of the people in India, but it exists for the entire population, that is, we the people. No person rightfully entitled to the benefits shall be denied the same on any grounds. Aadhaar gives individuals their unique identity and enables them to avail fruits of various social economic welfare measures. Hence, Aadhaar ensures dignity to the persecuted and marginalized. The humanistic aspect of dignity cannot be ignored, and Aadhaar acknowledges the same. Thank you.
Thank you. B1, you now have your time for rebuttal.
Yes, thank you. B2, thank you for your points. Much appreciated. The first point you made was merging of silos is prohibited under the Aadhaar Act. Now, I want to say that merging of silos is prohibited, but the extraction of information from one database of the government to the other database of the government is not prohibited under the Aadhaar Act, which means that if the government wants to share information with the other governments, which can be less secure than this government, it is possible. The second point that you made is about the autonomy, which is an important aspect under human dignity. Now, I would like you to know that when the Aadhaar Act was passed, they made it mandatory for people to code their Aadhaar number to file their income tax returns and to even obtain a PAN card. Now, if this talks about human indignity, I don't know what can. The next thing you spoke about is how people can approach the courts in case the information is violated. Do you mean to say that information should be so pricey that people need to go to the court to protect their personal dignity? I don't agree to this point. The next point you spoke about is how it leads to social benefits and transfer of social benefits. Now, I think Aadhaar is only a mechanism through which people get benefits. I think there are a lot more other measures. For example, the PDS, the public distribution system, does not work through Aadhaar, which still works, without quoting the Aadhaar number. So Aadhaar does not having an Aadhaar card does not mean I have human dignity. I disagree on that aspect. Now, also you spoke about how biometric and fingerprints are very basic information which can be shared. I would like you to know that biometric and fingerprints are the only unique things of an individual which are extremely private. If you ask me, I would never ever share my fingerprint to anybody unless I have the authorization that is absolutely secure. Now, to give you another example of how the Cambridge Analytica case happened, even though Facebook had extremely severe secure systems, the information was shared through a third-party app. So that is the point I'm trying to make. Third-party apps can misuse this information even if not the government. So the information is still not secure. With this, I would like to end my rebuttal. And yeah, thank you.
Thank you, B1, for your points. So now I shall list down the objections raised by my opposing speaker and try to address them one by one. So first, regarding data security concerns. So protection of an individual and safeguarding her information is actually inherent in the design of the UID project itself. From having a random number which does not reveal anything about the individual to many other features, the UID project keeps the interest of the resident at the core of its purpose and objectives. The UIDAI collects only basic information and does not collect sensitive personal information such as religion, caste, community, class, ethnicity, income. The profiling of individuals, therefore, is not at all possible through the UID system. Further, UIDAI does not reveal personal information in the Aadhaar database. The only response is a yes or no to request to verify an identity. Further, the UID database is not linked to any other databases or to the information held in other databases, which satisfies your query regarding that. Therefore, there are various criminal penalties envisaged against the fraud or unauthorized access to data. Regarding the involvement of third-party agencies are only allowed to collect and transmit the encrypted data to UIDIA servers and receive acknowledgements. So second point regarding violation of personal integrity. So I feel this interpretation of privacy is a very elitist concern. Crores of rural and urban poor see Aadhaar as a tool of empowerment rather. Aadhaar ensures the availability of welfare schemes to the poor and downtrodden. Further, as mentioned before, Aadhaar only collects basic information of an individual. So UIDAI has implemented strong security and data protection measures, which makes it impossible to steal the data. The UIDAI has the obligation to ensure the security and confidentiality of all the data collected. The data is secured with the best encryption features and is stored in a highly secure data vault. Hence, any fear of data misuse or manipulation should be avoided. The Aadhaar is an excellent initiative by the government to enhance social empowerment in India. As responsible citizens of the country, we have to play our part in promoting the common goal of instilling human dignity in all Indians. Thank you.
Thank you, B1 and B2. We shall now be moving on to the next competitive pair, C1 and C2. If you could please switch on your cameras and your microphone. C2.
Yeah, C1.
Is C2 here?
Hello, am I audible?
Yes, you are. Could you
Yeah.
please? Yeah.
Yeah, can I
C1
start?
over to you. Yeah.
Yeah, privacy isn't negotiable. It is a right of each and every citizen. Very good afternoon, my honorable judges, my worthy opponent, and all the ladies and gentlemen present here. I would want to start off my arguments by saying the legislative process behind the enactment of the Aadhaar Act is deeply flawed, and thus it is problematic. Therefore, I would back each and every argument of mine with certain facts, which will compel you to believe that my paradigm is better than my opponent's paradigm. Therefore, while Aadhaar initiative started itself as a contained unique identification program aimed at curbing the leakages of the welfare of the country, but whereas it later morphed itself into sprawling identity ecosystem, which will later integrate with each and every part of our life. Therefore, problems with Aadhaar and unique identification code ranges from security and private reasons and also large scale welfare reasons. So I would basically contain my arguments in three particular points. First is it would create a surveillance state. Second, I would talk about the concerns, and third is the legal and the technical glitches, technical drawbacks in that particular act and the program which is involved. Therefore, first I would begin my arguments by the surveillance state argument. Therefore, first, Aadhaar program helped create an infrastructure that would indirectly transform India. Hello, am I audible?
Yeah, you're audible.
Yeah. Which would indirectly create a surveillance state, which would definitely hamper the Article 21 and the right to privacy of each and every citizen, ma'am. Therefore, now I would move on to the process of consent. In the act, the consent is completely illusionary. When we are at a point where the consent for each and everything has been made mandatory by the government, whereas it was stated in the act that it was voluntary in nature. But here, everything is mandatory. Even if you want to sign up to an examination form, it is mandatory. But whereas if you don't really register yourself through Aadhaar, you can't even know what you're signing up to. Therefore, making the Aadhaar mandatory would definitely violate Article 21 and the two concepts involved in Article 21, which is the choice and the self-determination of a citizen. Therefore, and also making the government making the subsidiaries upon biometric authentication is completely worsened in this particular situation, ma'am. Therefore, I would now move on to the technical and the legal drawbacks in this particular program, in this particular act that I'm going to further argue upon. First would be UADAI's process of data collection and storage. It's deeply compromised. I would definitely state a humorous statement over here, which was stated by the KK Venugopal, that Aadhaar remained behind 13 feet wall and 5 feet thick 5 feet thick walls. Therefore, the Aadhaar, the security of the personalized information is deeply compromised. And now I would also want to state the opt-out option. There is no opt-out option in this particular act, ma'am. Therefore, the person, once he is enrolled, he doesn't have the option to opt out. And therefore, I would also talk about the grievance redressal. As we have gone through the act, it only states that only UIDAI can file a case in the court of law once the security is compromised. Therefore, what about the what about the rights of each and every citizen here? And therefore, now I would proceed to my legal arguments, where I would state that this particular bill of Aadhaar was introduced as a money bill, and the due consent of the Rajya Sabha was not obtained, and therefore legal process behind enacting such law is deeply compromised. And now when I also state the social media, when I state an example, when Aadhaar is linked to a social media platform, acts as a free as an platform of opinion. And whereas in a democratic country, freedom is very much important, freedom of opinion is very much important, that is being curtailed, and which creates a surveillance state, ma'am. Therefore, now I would back up my arguments with a few of the recent scams which are authenticate in nature. First is when the RTI, Right to Information query, pushed the UIDAI, it was realized that 210 government websites made the details of Aadhaar public online. Whereas once you simply perform a Google search, you would get to know the demographic data, that is the PAN card, IFSC code, religion, and the mobile number of each and every person, which is quite which will definitely hamper the right to privacy. And therefore, the Center for Internet and Society has also stated that 130 million Aadhaar data was available on the internet, which means 1 out of 100, 100 citizens' data has been on the public internet, which is very much dangerous for the privacy of each and every citizen. Therefore, so you would definitely talk about all the regulations and all the laws which are there, but I would certainly question your point on the implementation part of it. Therefore, now I would want to conclude my argument saying that the Aadhaar definitely infringes the right to privacy of a person under Article 21. Thank you.
Thank you, C1. We shall now be moving forward to C2.
May I begin?
Yes.
Yeah, thank you. In the case of Gobind State versus the state of Madhya Pradesh, the court held the following. There is nothing to prevent one from using the word privacy as a mean of freedom to live one's life without government interference. But the court obviously cannot use such a term, and hence it needs to be interpreted on a case-by-case basis. A very good afternoon, respected judges and my fellow opponent. I represent Team C2, and I'm here speaking against the motion that Aadhaar card infringement is infringing the right to privacy. The Aadhaar card, or more specifically, the Aadhaar number on the card, is a 12-digit number issued by the Unique Identification Authority of India and includes the recording of demographic data, such as the individual's name, address, gender, and date of birth, as well as biometric data, such as a picture of the individual's fingerprints, as well as iris scans. First, I would ladies and gentlemen, this Aadhaar card is purely a form of identification from the government, and it does not infringe upon the right to privacy. And I would like to prove these statements first by simply stating in the eyes of the law. As ruled by the Supreme Court in the case of Justice Puttaswamy versus the Union of India, the court stated the Aadhaar Act does not infringe upon the right to privacy. The Aadhaar Act, which is the statute behind the Aadhaar number and the Aadhaar card. Second, the Aadhaar system does not require details such as medical documents, religion, caste, etc., documents that are genuinely considered private to an individual. Third factor, there are in fact several provisions under Chapter 6 of the Aadhaar Act to prevent the illegal spreading of information, ranging from Article 28 to Article 33, which prevent private information from being released to the public. But if we were to look at this at another angle, we need to note the difference between identification of an individual and the right and the violation of privacy. And the simple identification and the identification of the individual is the entire point of the Aadhaar. If you were to apply for a passport or a visa, you provide essentially the same information. And if we do not have a problem with it when it comes to those authorities, why do we suddenly have such a problem with the Aadhaar Act? Another point I would like to bring up is some of my opponents have brought up the social security system of the United States. And a researcher at Duke University has found that identity theft by use of the social security number is one of the rising crimes in the United States. And the reason being that there is no biometric data to link the social security number with the individual. The Aadhaar is not only a means of providing subsidies for the poor, but it's also a means of ensuring crime is prevented. For example, ensuring that all individuals who are eligible to pay tax do pay them. I would like to immediately debunk some points that my opponent has made. He said that, respected sir, you said that in order to register for an exam, you need an Aadhaar card, and that is in fact completely false. The Supreme Court has ruled that you are not, in fact, it's ruled that all exams are, it's illegal for them to make the Aadhaar a necessary requirement for registration. Another point I would like to bring up is that with regards to religion that you had mentioned, the Aadhaar does not record religion by any means. In fact, that is a violation of privacy, and the Aadhaar does not deal with those types of provisions. In Article 29 under Chapter 6, it states no core biometric information collected or created under this act shall be shared with anyone for any reason whatsoever or used for any purpose other than generation of Aadhaar numbers and authentication of this act. Hence, further proving my point that it is the Aadhaar as a whole is not used for any other purposes other than identification. Another point you had made is that no individual other than authority can file a claim if their Aadhaar has been breached. That is not true. Again, that has been ruled by the Supreme Court that an individual is an amendment that has been made at the Amendment Act of 2019, that an individual can in fact file a complaint if their Aadhaar, if their private information has been violated. I would like to conclude by saying why, when this kind of information is so generally available to the public, and we've been dealing with this for a very long time, why is it that when brought under an umbrella, which is not only free, that helps a majority of the poor population in India, that we suddenly have an issue with it? Thank you.
Thank you. We should now be moving on to the rebuttal.
Yeah. Thank you so much for the points put up by my worthy opponent. So now ma'am, you started with a 12-digit number. Once your 12-digit number is, which contains the mobile number, it contains, and also you spoke about the passport details being linked with the 12-digit number, and also the IFSC code of a particular person. So when that particular thing, and as I have recently stated, the scams which have been stated by the RTI and in the UIDA, and also when the Center of Internet Society has stated that 130 million accounts, Aadhaar accounts have been put online. So 12-digit number matters a lot. If IFSC code of a person is being traced, it is a danger to his bank account also, which would, and later I would also state that, ma'am, you have spoke widely about the acts, but I would certainly deal into its implementation part. So you haven't provided any solution regarding the concept of profiling and the concept of self-censorship, and also how that particular thing is not endangering the freedom of a particular person. Therefore, the concept of data protection, personal integrity of a person, and the bodily integrity of a person has been not dealt in your arguments, ma'am. Therefore, these are few of my points which I would want to state. And also, when we also talk about few of the very much documents that a person particularly has, that is the passport and the other things that you have stated, and also the medical insurance. So these are some of the things which are very important to maintain secrecy and privacy in. These cannot be, put on public, and the laws which were being framed for the repercussions once the data is being made public is not effective, and there are many implementation gaps in implementing those particular laws, ma'am. Therefore, I would want to conclude that Aadhaar definitely infringes the right to privacy under Article 21, and also hampers the concept of choice and self-determination of a person. Thank you so much.
Okay, I'm beginning. Sir, you mentioned, may I begin?
Yes.
Sir,
do we have Sir rebuttal for this?
What? I'm sorry?
Yeah.
So,
okay.
Sir, you mentioned scams. Do people not forge passports? Do people not forge? No, your point was that there are several scams, but regardless, in the world, you cannot prevent crime. That's an idealistic view to assume that
the
no
concept
scam
of passport is irrelevant over here.
Please do not interrupt the speaker while she's speaking.
Let me interfere.
Excuse me, you're not
it would be better not to ask questions mutually, just address to the questions raised by the other speaker.
Yes, so that's what I plan to do. So,
Right.
as you said, you were talking about scams, and I would like to say that there's crime everywhere. You can people forge passports, so you cannot say that just because there have been certain scams that the Aadhaar is not a viable means of protecting the right to privacy of an individual. Second of all, the bank account, what you mentioned, the statement about the bank account, it is not required for the bank account to be linked to the Aadhaar. It is optional, but it is not a requirement. Third of all, choice. It is a choice of the individual to sign up with the Aadhaar card. It is not required. However, it may seem otherwise. When stated in laws, it is not required. So hence, another fact I would like to bring out is that you stated that there's no bodily autonomy. Like I did not mention anything about bodily autonomy in my argument. So if its basic identification of an individual violates the right to bodily autonomy, then are you telling me that the compulsory medical examinations that are there in the country is also a violation of bodily autonomy? You are willingly going to the Aadhaar office, willingly allowing them to take your fingerprints, to scan your irises. It is your choice. And hence, it does not infringe upon bodily autonomy, neither the right to privacy. Thank you.
Yeah, I would need just 10 seconds to summarize my argument.
I'm sorry, but you do not have the
Let's
allocated
conclude
time.
it.
Okay.
We should,
Yeah.
So
So first of all,
your arguments are already taken on record,
okay,
Mr. Sivan.
okay, sir. Okay,
So don't worry about it.
yeah, sure.
We can move to other team if there are other teams.
Thank you so
yes,
much.
could D1 and D2 please switch on their cameras and microphone? D1 and D2.
D2 here.
D1, are you here? Seeing that D1 is not responding as of now, if the judges allow, D2 shall proceed with our contention.
How many more teams are there?
We have team codes up till F.
Okay, D, E, F. So E1 has already addressed.
So E1 had by mistakenly written her name as E1. She was actually A1.
Okay, let me just correct. So that's A1.
Yes, sir.
All right.
If D1 is not here, maybe we can move on to F or E for now, and then maybe come back to D.
Yeah, otherwise means their own routine may get disturbed. So let's start with E, and D they can join later.
All right, sir. E1 and E2, please switch on your cameras and microphone.
E1 here, ma'am, am I audible?
Yes, you are.
Okay, can I start?
Yes.
In the words of Honorable Justice D.Y. Chandrachud, constitutional guarantees cannot be compromised by the vicissitudes of technology. A very good afternoon to one and all present here. This is team E1, and I am strictly for the given motion. Aadhaar card, an infringement of the right to privacy. The 9-judge bench of the Supreme Court in the Puttaswamy versus Union of India case held that the right to privacy is a fundamental right protected under Part 3 of the Constitution of India. The infringement of this very right to privacy has been the focal point of Aadhaar debate for years now. Time and again, the government has not only justified but glorified the somewhat easily permeable security system of the Aadhaar card, with absolutely no regard for civil liberties or the right to privacy. The CEO of UIDAI has gone on to say that the Aadhaar card is a foolproof repository of citizen-sensitive data. However, the statistics show otherwise. In 2019, Aadhaar details of 7.82 crore Indians were leaked online by the IT Grids India Company of Telangana. The government of India has already accepted in the Supreme Court that Aadhaar details of numerous Aadhaar card holders have been leaked online. The recent case, that is an RTI query, pushed the UIDAI to reveal that Aadhaar information was being leaked online through 210 official government websites. Furthermore, an investigation led by the Tribune leads to some very interesting findings. Anonymous individuals were ready to furnish Aadhaar details of anybody with an Aadhaar card for a meager amount of only rupees 500. An additional rupees 300 will even let you print those Aadhaar cards. I could go on with examples, but the point here is very clear. The current security system of the Aadhaar is not robust enough to protect the privacy of the individuals. To further elucidate my stance, I would enlist 5 ways in which the current Aadhaar system is a serious blow to the right to privacy of the citizens. Firstly, data security, possibly the narrowest interpretation of privacy. The information stored in the CIDR is not safe for the simple reason that the 13 feet tall and 5 feet wide walls are not leakage proof. Having mentioned a smorgasbord of data privacy related cases earlier in my speech, the question no longer is whether a data breach is going to take place, but when such a data breach is going to take place. Even if we were to assume for a minute that our data is secure with the government, the Aadhaar enabled payment system under the Aadhaar makes citizens very susceptible to identity theft and identity fraud. The essence of AEPS, as put forward by Prime Minister Narendra Modi, is your thumbprint is your bank. Now, let me remind this August gathering that fingerprints are very easy to replicate. The second concern is with respect to personal integrity. The feeling of discomfort in sharing personal information with persons or institutions that I do not wish to share such information with. Team B2 said that it is a very elitist concern in the interpretation of privacy, but such comments are only an attempt to trivialize the debate of privacy. Matters of privacy differ from person to person. The third contention with regards to privacy is bodily integrity with respect to collection of biometrics by the Aadhaar card. It is no longer, it says that it is voluntary under the Aadhaar Act, but we all know that to avail any basic service in the country, Aadhaar is very important. So this line of argument was very much stressed upon in the Pan Aadhaar case in the Supreme Court by senior advocates Shyam Diwan and Arvind Dattar in April 2017. The fourth concern, and what I feel the most important concern, today, information about my life, such as train travel history, air travel history, employment records, banking history, health records, all of these is available in different disconnected data silos. The only person who can paint a full picture of my life through these data silos is me, because I have access to all these disconnected silos. The seeding of Aadhaar into every database and subsequent interlinking gives the government the power to create a picture of my life. Aadhaar becomes the interlink between the hitherto disconnected data silos. This gives the government to profile my life with the help of a single identifier, and the very suspicion that such profiling may take place will lead to self-censorship and in turn stifle dissent. The last and not the least, entrepreneurs and technocrats have gone on to say that they wish to use this Aadhaar technology to do good in quotes. However, by doing good, they mean data mining and using big data analytics techniques. The problem with that is the creation of a personal data-based economy, which will monetize people's personal information without creating significant awareness and legal safeguards to protect privacy of the individuals. To conclude, the packaging of the Aadhaar as a welfare-enhancing project is nothing but sugarcoating of what is becoming a surveillance and a data mining tool. We cannot afford to risk the civil liberties and privacy of the citizens for the government's entrepreneurial and unsafe ventures. Thank you.
Thank you. We may now move to E2.
Can you just give me 2 seconds, please?
Yes, sure.
Thank you. So sorry for the delay. Am I audible?
Yes.
Thank you. In the social jungle of human existence, there is no feeling of being alive without a sense of identity. This is said by a German-American development psychologist, Erik Erikson. Respected judges and my worthy contender, when negating the topic Aadhaar card infringement of right to privacy, the basic value premise I would be building my arguments on is the unique identification for each citizen. Let us take a look at what the court says about this, right? On one hand, it gives individuals their unique identity, and on the other, it enables such individuals to avail the fruits of welfare schemes of the government. The scheme ensures dignity, and this facet of dignity cannot be lost sight and needs to be acknowledged. This is said by the court itself. Now, let us take a look at the current situation, right? It is imperative to note that the Aadhaar scheme, which was first introduced as a means of targeted distribution of subsidies, is today being implemented towards a variety of purposes, including the fight against black money, transaction authentication, and even KYC, know your customer requirements, for banks and telecom companies. The mere progression of Aadhaar card shows us how important the value of Aadhaar card in today's country is. Let us move on to my contentions, respected judges. My very first contention would be the definition on the infringement of privacy. If we take a look, if we consider the protection of privacy law, we can see that there are specifically 11 clauses telling us about the infringement of privacy, right? When we go through specifically through each clause, the one thing we can find is that there is no connection established to the policy of the Aadhaar cards or the policy of the UIDAI. The Supreme Court categorically recognized certain data protection principles. It recognized the loopholes in the Aadhaar cards policies. It is already recognized, and it has brought in certain principles such as data minimization, restricting collection of data, data retention, letting the data stay out only for a limited number of time until the purpose is deemed, purpose limitation, limiting the scope of purpose, and data security, securing the data. The Supreme Court struck or read down certain portions of the Aadhaar card which did not fulfill the proportionality test, after which it was deemed constitutional. However, aside from these provisions, the Supreme Court held that the Aadhaar Act on the whole as a law serves as a legitimate state aim and is proportionate, thereby being a reasonable exception to the right to privacy. Moving on to my next contention, let us see the amount of sections they have struck down, the courts have struck down. Regulation 26C of Aadhaar Authentication Regulation 2016 has been struck down as it pertains to authentication transaction related to metadata. It allows to store and maintain authentication transaction data, which are inter alia contain information on metadata related to transaction. Section 33, Clause 2 allows identification and authentication data to be disclosed in the interest of national security. Even this section, even at the discretion of national security, even this section has been taken down. Data retention beyond 6 months has been made impermissible. That is, the whole keeping of data after a limited period of time after the purpose is accomplished is illegal from now. Section 29, Clause 1 puts the onus on the UIDAI that no core biometric information collected or created under the Act shall be shared with anyone for any reason to use for any purpose other than the generation of Aadhaar numbers and authentication under this Act. If a Section 29, Clause 1 itself says this, what more can the government provide? Let us read Section 33, Clause 1, right? A whole section for the citizen betterment. Clause A says individual whose information is sought to be released is given an opportunity of hearing. Clause B says that individual is to be given the right to challenge the disclosure of his or her information. Let us take the modification of Section 47. The whole modification of Section 47 is to include provision for filing complaints by an individual or victim. There are two aspects to the court's judgment on Section 57, right? One part of the section was changed because the whole term for any purpose was seen to be susceptible to be misused, because of which the term purpose, any purpose, was read down to the meaning purpose backed by law, while Clause B states that this law made would be subjected to judicial scrutiny. Another part of Section 57 has been held to be unconstitutional because this part of the section enabled corporate bodies and individuals to seek authentication. Let me conclude and crystallize my point, my worthy contender. Aadhaar card, because of its wide recognizability, has made things easier for the citizens. It has become the passport for the Indians. It has become an official document that is widely accepted in all parts of India. And let us accept the fact, guys, because of the existence of this document in our ballot, it has become easier for us to move around India and to accomplish purposes, right? When engaging in a FAQ session in Twitter, the question that UIDAI faced the most is whether the linkage of the bank to Aadhaar card is safe and relevant, to which the UIDAI replied, as your bank information is not shared by the bank with anyone else, no one can have information about your bank account just by knowing your Aadhaar number. Also, UIDAI or any entity for that matter will not have any information about your bank account. Let's take an example. You give your mobile number at various places to various authorities, right? Such as bank, passport authorities, income tax departments. Does this mean that the telecom company, does this mean that the BSNL or IDEA have access to your bank information, income tax returns, etc.? No, obviously no. Similarly, when you provide Aadhaar number to various service providers, your detail remains with the respective service providers, and no single entity, including the government or UIDAI, will have access to your personal information spread across. Thank you.
T1, you now have your time for rebuttal.
May I start, ma'am?
Yes, please.
Okay. So, firstly, it's important to remember, my worthy opponent, that the debate today is not on what the Aadhaar was destined to be, but what it essentially is at the moment. By subjecting the phrase infringement of privacy to a narrow interpretation, the opponent has made a very unsuccessful attempt to justify the government's failure to protect the fundamental right of privacy of the citizens. For those who advocate the logic that we are already being surveilled as a defense for the surveillance of the government through the Aadhaar system, there are four reasons why this is not a satisfactory response. One, none of them is all encompassing in the same way as the Aadhaar project. Two, there is a genuine element of consent in most of these cases. Three, there are technologies such as encryption and virtual private network and so on to protect ourselves, partially at least, from surveillance. And four, to say that because we are already being surveilled, we should not be questioning the Aadhaar project is akin to saying that because we have been robbed in the past, we should sleep with doors and windows open now. Now, for those who advocate the legitimacy of the Aadhaar on the lines, I have nothing to hide. That it is only those who are doing something wrong who should be worried about the linking of their Aadhaar number to various databases. To all those making this argument, kindly share your social media passwords and with me and grant me full access to your mobile phones. No? Why? I thought you had nothing to hide. Three, for those who are mentioning various statutory provisions and laws which will protect the privacy, saying that the law will take care of the infringement of privacy. One of the law is either silent or weak on several of these aspects. The safeguards, say against data breaches in the Aadhaar Act, are weak. Further, the implementation of the law is even worse. Publishing UID numbers is punishable by up to 3 years in jail. Yet after the Aadhaar leak scandal in which several state departments and central ministries were found to be violating the act, the UIDAI has not filed a single FIR against anyone. To make matters worse, for a very long time until the recent amendment, if data was leaked, only the UIDAI, not the affected person, was authorized to file an FIR under the Aadhaar Act. We do not even know how many people's right to privacy has been infringed, and they have no methods of addressing the issues up until now. In a nutshell, the Aadhaar Act is weak, but its implementation is far worse. Thank you.
E2, over to you.
Thank you. Destined to be? Did you just hear the whole contention as destined to be? Of course, I had mentioned the destined to be statement, because unless you know what you're destined to be, unless the government says what the whole plan is destined to be, you never know what you want to achieve, right? If you have to come to a point where you have to achieve things, you obviously have to have an idea of what you're destined to be. You had also stated that my worthy opponent has failed to show how the government seems to secure the data. I have completely shown how the amendments were made because the government realized the problems or the loopholes that were there in the Aadhaar Act. I'm not saying that it was never there. I'm saying that it was there, but it is already realized. All the problems that you have clearly stated were already realized. Also, you have come forward and asked whether I can give you my password, and if not, that means I have nothing to hide. The government doesn't ask for your password. The government doesn't come and ask for your username. All the government is saying is that I can provide you a software to link your laptop to your mobile. And are you telling me that you are taking this as the government is asking your password? All the government is providing you in a technical way is it is providing an app in your app store to say that it links your app to the mobile phone. And you obviously, if you are a technological person, would download the app for better convenience, right? You, my worthy opponent, had said that about the security system that is not robust enough. This does not show that the Aadhaar infringes the right. This shows that the security system of the country is weak. Yes, I agree. Security system of the country might be weak. The security system is not robust enough to secure the Aadhaar card. But that does not mean the Aadhaar infringes the right. That means we should enhance the security system. Every coin has two sides. Your Aadhaar links your data, yes, but that was done to make the things better for even the poorest of people. When you weigh the things, when you weigh the pros and cons, the pros obviously outweighs the cons. Also, let me conclude by saying whether the Aadhaar Act violates the right to privacy and is unconstitutional on the ground. With reference to the earlier Supreme Court decision that determined privacy to be a fundamental right, the order states that any restraint on privacy must meet three tests, right? Backed by law, legitimate state aim, and proportionality. The existence of Aadhaar Act and delivery of welfare benefits already fulfills the first two requirements. The order noted that the third test of proportionality has also been met. The order clearly noted that because the purpose of the act is to ensure deserving beneficiaries of welfare schemes are correctly defined. It also achieves the balancing of the two competing fundamental rights, right to privacy.
Sorry to interrupt, E2, but your time is up. Could you please summarize in 10 seconds?
Just give me 5 seconds. Yeah, just give me 5 seconds. The whole Aadhaar Act does not just achieve linking the whole people, but it also achieves the balancing of the two competing fundamental rights, right to privacy on one hand and right to food, shelter, and employment on the other. Thank you.
Thank you, E1 and E2. Before we move on to the remaining two competitive pairs, would the judges like to break for a short interval?
I think we can continue. So just in case, how are you feeling, Manisha and Wasim?
Yeah, I think we can go ahead. We don't need a break.
All right, ma'am. Then we shall proceed with F1 and F2. If you could please come online. Switch on your cameras and your microphone.
I hope I'm audible and visible.
Just a minute.
Yes.
This is F1, you say?
Yes.
Yes, F1 and F2.
I'm F2. Am I visible and audible?
Yes.
Yeah.
Shall I start now?
Yes, of course.
I thank the executive for recognition. Ends do not justify the means. The mere existence of a legitimate state aim does not ensure that disproportionate means by which have been adopted to achieve it. Members of the jury, Madam Chairperson, fellow participants, a very good afternoon. The motion before the House is that the Aadhaar Act infringes right to privacy, and I vehemently, in the strongest words possible, support the motion. Members of the jury, from verification log, it is possible in the Aadhaar to locate the places of transaction. Things such as these violate the very essence of right to privacy. The aggregation and concentration of information, of sensitive personal information, in fact, under the Aadhaar Act is impermissible because it is capable of being used to, in fact, affect every aspect of an individual's personal, professional, and social life, and thus it is violative of Article 19(1)(a), Article 19(1)(g) of the Constitution, and also Article 21 of the Constitution. Members of the jury, at this point, it is pertinent to understand that such aggregation of information, in fact, is also infringes the principle of informational privacy, which was established in the case Puchaswamy versus Union of India by the Supreme Court. The collection and storage of data with the government is under the Aadhaar Act is also violative of right to prevention from self-incrimination, also violative of the right to bodily integrity, and all these rights are enshrined actually in Article 20, Clause 3 and Article 21 of the Constitution. The general and indiscriminate retention of data, of the personal data, including metadata, in fact, has the excessive possibility of being used for potential surveillance, and that violates the very essence of right to privacy. Members of the jury, at this point in time, it is high time that we accept the fact that the question before us is not whether the data will be breached or whether there will be hacking. The question before us is when there will be hacking, and it needs no more emphasis from my side that private espionage groups or foreign governments will in fact exploit the data vulnerabilities on our system. Under Aadhaar Act, requesting entities can withhold identity confirmation of individuals, and this is violative of the widely accepted principle of data minimization, which actually mandates the fact that data collecting groups delete personal data at the very time that the purpose for the collection has been fulfilled. And also coming to the fact that the Aadhaar Act allows the collection of metadata, which can easily use which can locate the individual's location through IP addresses simultaneously. Members of the jury, it is possible from the Aadhaar database to track the location of individuals, and no emphasis from my side that it is clearly violating the right to privacy. The whole structure of Aadhaar has the potential of surveillance, and it also has the potential of leakage. For instance, I would like to draw your attention, members of the jury, to the biometric database, which is controlled by the CIDR. Now, the biometric database works from a deduplication technology, which is owned by a source code. Now, the source code is not owned by the government of India or UIDAI. It is owned by a foreign corporation going by the name of L1 Identity Solutions. Now, UIDAI actually has a contract with L1 Identity Solution, and UIDAI is only a mere licensee. Now, the question that I put before you, members of the jury, is that would this House allow data of 1.3 billion people to be at the to be subject of a mere terms and conditions of a simple contract? This is a potential. This has the potential of national security, members of the jury. And when this Aadhaar Act actually allows this Aadhaar to be seeded into every database, and as has been pointed by my for the fellow participants who have already stated the fact that how it can be used to gain access to our lifestyle choices, our individual preferences. And at this point in time, members of the jury, allow me to be as clear on this as anyone has ever been on anything. One right cannot be taken at the behest of another. I would not want subsidies at the expense of my individual right to privacy. Though both can coexist at the same time, and that is my contention. Members of the jury, at this point in time, I would, in order to uphold the democratic values of the Constitution, I urge you to vote for the proposition. I urge you to let the motion stand. Very, very proud to propose. Thank you so much for your time.
A very good afternoon to one and all. May I start?
Yes.
My code is F2 and I'm opposing the motion that Aadhaar card infringes right to privacy. After duly listening to my worthy opponent's arguments, I respectfully disagree with my worthy opponent as he failed to understand the difference between Aadhaar regime prior to 2016 and Aadhaar scheme after the commencement of Aadhaar Act 2016. Also, there are a lot of material discrepancies in my worthy opponent's contentions as he has completely ignored the existence of regulations governing the Aadhaar scheme. I'll duly deal with all the fallacies in order to prove that our premise is better than their premise. In opposing this motion, I have structured my arguments in a way that firstly, I'll be expounding upon the meaning and status of right to privacy in the Constitution. Secondly, I'll be elucidating the aims and the functioning of Aadhaar card. And finally, I'll be contesting all the assumptions made by my worthy opponent regarding the vulnerability of biometric and demographic information by referring to various Aadhaar regulations. As far as the meaning of right to privacy is concerned, Black's Law Dictionary describes it as a right to be let alone. With regards to the information, which is the point of contention at hand, the right to privacy refers to the specific right of an individual to control the collection, usage, and disclosure of personal information. And it is a trite law that right to privacy is recognized as a fundamental right within the ambit of Article 21 of the Constitution. As the principles are settled regarding the status of right to privacy, let me delve into the aims of Aadhaar card. Aadhaar is aimed at providing good governance, enhancing socio-economic rights by delivering the government-funded benefits, subsidies, and services to the deserving citizens. In order to achieve these aims, UIDAI collects the biometric and demographic information and stores it in the Central Identity Data Repository. This collection and storage of data is fully in consonance with para 311 of Justice Puttaswamy versus Union of India case, wherein it was held that the state can collect, store the data for protection of revenues, which is the situation at hand. As I already said, my worthy opponent failed to understand the distinction between the Aadhaar regime prior to 2016 and after the commencement. Herein, the commencement of the act, herein prior to 2016, Aadhaar was used for establishing identity of the persons in various aspects by government and private bodies, and there was no law governing the scope of Aadhaar. Hence, there were privacy concerns regarding the same. But after the commencement of Aadhaar Act, the scope of it is restricted to be mandatorily used only for authentication, only in those schemes where the benefits, subsidies, or services are being driven by the Consolidated Fund of India. Hence, there is a specific law governing the scheme in a right manner without infringing any given person's right to privacy. And herein, now I would contest all the assumptions made by my worthy opponent regarding the collection and storage of data and biometric information. As the data is collected by UIDAI agencies, it is stored in CIDR in an encrypted form, which cannot be accessed by anyone. This is an accepted view about the process. even in the Puttaswamy judgment, which cannot be deferred. Hence, the argument that biometric data is available to the government and other private entities, making it easier for data mining or profiling, is seriously flawed. Herein, the authentication process with any requesting entity, may it be a government entity or a private entity, is purely carried by strictly adhering to the Aadhaar Authentication Regulation 2016, wherein regulation number 3 clearly puts forth only two types of authentication, that is yes or no authentication and eKYC authentication. These types of authentications only establish a person's identity with the requesting entity. So there cannot be an assumption that our private information is being provided to the requesting entity. Hence, there is no breach of anyone's privacy by the Aadhaar card. And moreover, having said that, I request my worthy opponent's attention to the regulation number 3 of the Aadhaar Sharing of Information Regulations 2016. This is a different regulation from the previously cited one, wherein it states that core biometric information will not be shared with anyone for any reason whatsoever. And pertaining to the demographic information and photograph, if the Aadhaar card holder gives permission to the requesting entity, then they will be duly provided. So it is very reasonable to conclude that biometric information is totally inaccessible and demographic information will be shared upon the consent by the Aadhaar card holder. And hence it is meeting the very definition of right to privacy with regards to the information. So all these contentions and regulations in no way allows a person to deduce that Aadhaar infringes the right to privacy. Thank you.
We shall now be moving to the rebuttal.
Members of the jury, at this point in time, it is very pertinent to understand that the opposition comes here and tells you the meaning of privacy. Now, if I were to draw an analogy, the Attorney General of India went to the Supreme Court and said, since there is the Hindi word for privacy is nijta, and it is not colloquially used in the Indian language, privacy does not matter to Indians. That was the argument of my opposition as he tried to explain the meaning of privacy. Members of the jury, the opposition comes here and tells you that I have ignored the regulations after 2016. Members of the jury, at this point in time, I would like to draw your attention to the fact that at no point in time I have ignored the regulations after 2016 or the amendments after 2016. My only sole contention was that since the seeding of databases happens through Aadhaar, you put your information at n number of places, and when you combine all those information at one place, what you get is a reconstructing of your profile, and that is what legit profiling is, and that is done through Aadhaar. The opposition comes here and accepts the fact that CIDR owns the biometric data, but at the same time, it does not say anything about the CIDR or the UADIA does not own the source code. A foreign corporation owns the source code. To say that it is encrypted, a third party also always has an access to all the data because they are the owners of the source code. The opposition has completely ignored that point. The opposition comes here and says that there is no privacy violations through Aadhaar. While it is obvious that the Aadhaar scheme severely impairs informational self-determination in individual privacy, dignity, and autonomy. All the Aadhaar framework does, it does not sufficiently assuage the concerns which have been raised over a period of time, and the very operation of the project, in fact, is a violation of the right to privacy. At no point in time, the opposition has come and has given any reply to the fact that what are they doing about the seeding of databases? What are they doing about the information which is being given to n number of companies through the Aadhaar? What are they doing about that? Then the opposition has no answer for it. That is my contention, members of the jury. Thank you so much.
Oh, may I rebut?
Yes.
So my worthy opponent contended regarding the Attorney General's observation, and he has clearly failed to elucidate upon the question that if the Aadhaar card is really infringing the right to privacy, the Aadhaar Act, which is governing the Aadhaar card scheme, would have been struck down by the court in Justice Puttaswamy case, which is not clearly the scenario. And as far as his third party concern regarding the foreign company which is owning the source code, any requesting entity, whenever there is whenever there is a biometric information or any ID, the unique ID number is given to the requesting entity, it will be processed through in an encrypted form.
South Indian.
Hello.
Please continue.
So it when the requesting entity gives the when we give the biometric information to the requesting entity, the regulation number 9 of the authentication regulations 2016 will govern the process, wherein it will that data will be provided provided to the authority in a PID block form, which cannot be decrypted very easily, and later on, and it will be duly provided to the CIDR, and the CIDR will be giving the identity of the person, whether as to he is the exact person or not. There is no kind of decryption, and no requesting entity will be able to acquire the data. And moreover, he while he was contending regarding the subsidy, he told that he'll not do not need any subsidies at the grave of his right to privacy. The thing is, you might not need the subsidies for your concern, but the public revenue, which is crores of rupees, are being saved by the functioning of Aadhaar card, is clearly satisfying the test laid down in the Puttaswamy judgment. So it is clear that public revenue is more important than your public revenue is more important than mere mere concerns regarding right to privacy. Thank you.
Thank you. Seeing that D1 is not online yet, I request D2 to come online, put her microphone and camera on, and if the judges permit, be given a permission to speak for 7 minutes.
Yeah, sure, go ahead.
Am I audible and visible both?
Yes, you are.
Shall I start now?
Yes.
We, the people of India, having solemnly resolved to secure to all its citizens justice, social, economical, and political. So with this, today, I'm going to start my debate. A very good afternoon to one and all present here. So today we're talking about a scheme which seeks to provide social and economic justice to everyone. And it is ironical that we are the ones who intends to deny them that by questioning it on the basis of privacy. So before moving on to my arguments, I'd like to lay down the blueprint of my arguments today. I'd like to argue on 4 limbs. First, the objective of the Aadhaar Act. Second, the balancing act between right to privacy and right to food and shelter. Third, the technical aspect of how the data is being protected by the Aadhaar Act. And fourth, the international practices. So the Aadhaar scheme, which was conceptualized in the year 2006 and launched in the year 2009 with the creation of UIDAI, has secured the enrollment of almost 1.1 billion people in the country. The object for the scheme and the act is to provide unique identification to one and all for availing different schemes, social and economical, and most importantly, the subsidies. So the failure to establish identity of an individual has been for long a hindrance for successful implementation of these particular schemes. So what my other worthy opponents has been consistently hampering upon was they were trying to highlight that the concern is based on dignity as a facet of right to privacy. So while addressing this, I'd like to take you to Section 7 of the Aadhaar Act, and which is aimed at offering subsidies and benefits to the marginalized, and it has become an aspect of social justice, which is also an obligation of state and has become a fundamental right of people to claim it. So insofar the balancing is concerned, it should be examined at 2 levels. First, whether there's legitimate state interest, and second, whether it has been balanced properly. So while I talk about the legitimate state interest, I'll say there's minimal intrusion into the privacy, and the law is very narrowly framed to achieve the object. It is found in a balancing test that social and public interests outweighs the particular aspect of privacy. There needs to be balancing between two competing rights, that is fundamental right to privacy on the one hand, and on the other hand, right to food and shelter on the other hand. It should be noted that axiomatically both the rights are founded on human dignity, and the balancing here is met as the enrollment in Aadhaar of the underprivileged and marginalized section of the society is in order to avail the fruits of the welfare schemes of the government and actually amounts to empowering these persons. The inroads into the privacy rights where these individuals are made to part with their biometric information is minuscule. It is coupled with the fact that there is no data collection on the movements of such individuals when they avail under Section 7 of the Act. From a technical perspective, moving on to my second limb, there are a lot of protections taken by the government to prevent data breach. But however, I would like to highlight the four most important technical aspects. First, the authority does not collect purpose, location, or details of the transaction. The second, the answer, like for example, if I ask that I need details of X, Y, Z, the answer which will be given to me is in binary, that is in yes or a no, about the authentication of the people concerned. I will not given a barrage of information about people. Third, the authentication process is not exposed to the internet world, it is stored offline. So the concern of getting into one server and taking out online data through internet clouds is untenable. Fourth, the security measures as per the provisions of Section 29 and 38 as well as Rule 17 of regulation are strictly followed and adhered to. I would like to emphasize the privacy is ensured with the very design of the Aadhaar Act because it is backed by minimal data collection, federated database, optimal ignorance, and there is no pulling of data of any kind whatsoever. All security numbers are followed, which can be seen from strong encryption, adoption of best-in-class security standards, and strong audit and traceability as well as fraud detection. The original biometric images and fingerprints, iris, and face are archived and stored offline as mentioned before, and they cannot be accessed through online network. And the biometric system has a success rate of around 99.86%. Above all, and the most important point which so many of us have failed to address is that there's an oversight by Technology and Architecture Review Board and the Security Review Committee, which consists of very high-profile officers to look into the security measures, and they're the ones who take prompt actions regarding any kind of data threat, even before it is attempted to. Also, to reiterate that the right of privacy is not an absolute one and can be limited on the basis of reasonable exceptions, as also mentioned in para 297 and 298 of the Puttaswamy judgment. However, I do respect the concern of data leak is beautifully portrayed by my worthy opponents. I would like to say no data is safe today. It might seem to be contradictory, but the truth is this today. The very fact that we are having this debate on a Zoom platform, even after knowing that there is a threat to data breach, is it's kind of an explanation of my point that no data is safe today. So the basic key here of this entire discussion is to check whether there is proper data protection measures taken by the government and whether the pros outweighs the cons. Also, it's not that India is the only one who's using biometrics. Many, like the USA has pointed out before also. USA, Australia, Canada, Japan use fingerprint identification for entry into their country. Others, like the UK, France, Netherlands, issue biometric response. Finland, among others, issue biometric resident permit cards, and uniquely, New Zealand's Inland Revenue Department uses voice-based identification, which they claim that it saves 15,000 of telephone minutes every year. Increasingly, offices around the world are using fingerprint scanners at access points to identify employees. The UIDAI is barred from revealing personal information in the Aadhaar database. The only response is permitted is through yes or no to requests to verify an identity. The same applies when a private agency uses an Aadhaar number for identification, ensuring that no one besides UIDAI has the access to biometrics. The Aadhaar Act 2016 provides for a penalty ranging from Rs 10,000 to Rs 1 lakh and imprisonment of up to 3 years. Data theft could bring them a punishment of minimum of Rs 10 lakh and up to 3 years in jail. So the legal provisions are deterrent enough to deter people to address the concern of the people that there is no data privacy
your
breach.
Time is up. Could you please summarize very quickly?
Yes. So I'd like to summarize that when I say about the technical aspects, how the data is being protected by the government, the steps taken by the government, and how the international arena has adopted biometric system as one of the most impactful authentication system, I would like to say India should not be far behind. And the very fact that they have collected so many data in just a span of 8 years and it's showing such success rate and in such a robust country like India is itself an achievement. Thank you.
Thank you, D2, and thank you to all the participants and the judges for coming and spending time and giving us such great views. Indeed, it's no doubt that that information has become the most important currency in today's world, whether it's India, where we have the Aadhaar judgment, which is so crucial and is such landmark in nature, and with the PDP bill also coming in. We also have countries such as in the EU who have taken the effort to draft something as important and holistic as the GDPR. Now, whether it's Canada with the landmark judgment of R versus Spencer, or the recent case of Apple, where a private company took upon itself to safeguard the information of their consumers. With this, we would love it if the judges could share their viewpoints, not only on the subject of the debate, but also on how the participants performed today.
Sure, I would want to congratulate all the participants. I thought, Vivek, would you want to go first?
No, please carry on, carry on.
Thank you. So I take this opportunity to congratulate all the participants. I think each one of them was exceptional, thorough with the research, and they made some very, very good points. So I think all the judges, we have a tough job on our hands. All I would want to say is that even though there would be one winner, I don't think there is going to be a loser in this. So it was very, very well done. I congratulate each and every one of them. Thank you so much for having me.
Vivek, go ahead. I'll follow you.
No, Manisha, you carry on. I'll go in the last.
All right. It was a pleasure to have heard all the speakers. Everybody was great, and the points put forth were probably better than what I would have thought about when I was probably your age. You guys were great. I think the articulation, the way you presented the argument was par with any lawyers who are probably practicing in the high courts or the Supreme Courts or the good tribunals as well. I would say that a little more research and little less, like don't try to put a point forward just because it's funny or just because it's demeaning to the other side. Put for points which are more, which make more sense to everyone and which are actually the crux of the argument here. Having said that, there were points which are completely left untouched by a lot of you with regards to the fact that if you all are saying that there is a visa or a passport information, then what was the need for Aadhaar ever? But again, I am not going to present my views on it. It was great to hear all of yours. And I wish you the best. It was a pleasure to have been a judge on this. Thank you so much.
Yeah, it's very nice to hear from all of you. Means you did pretty well, pretty good. And as Manisha and Wasim said, means it was quite competitive to hear all of you. It was a well prepared, thorough debate, and of course, means there were different perspectives that you all brought in. And despite there are only two sides for and against. But at the same time, what means the creativity which has been used by several participants was impeccable, and I really admire that particular creativity. Because if at this stage you are using that creativity, then in coming time, definitely you can bring so much of good things to the profession. And of course, means Aadhaar is something means which is quite debatable even today, despite the Supreme Court judgment has come into vogue. And at the same time, why it is so? Because ultimately the data which is going into the system of the individuals is still unprotected, and there has been large scale violations. So whatever mechanism, the legal mechanism which we can provide to any system, unless the system itself goes in a way that it protects the data and the very identity of people, then in that case, if it does not provide so, then the system is itself failure. So that my simple test is what we are desired to achieve from a particular system. If that system achieves that, then it's very, very good system. If the system fails in achieving that particular aspect, then the system is failed system. So Aadhaar Act, while it advise means, of course, they are the for and against. So if I have to give my opinion, while it is required to achieve a particular demography in Indian citizenry and for the benefit of Indian citizens, at the same time there are large scale lacunas which have to be still filled. So be it. I congratulate all the participants and the organizers, Mr. Zaiwalla. As I am seeing, Mr. Saroj Zaiwalla is very much on the screen. So it's a wonderful initiative that the Burnished Law Journal has started, and my best wishes to all of you. Thank you very much.
Thank you so
Thank
much
you.
for your insightful words, judges. Indeed, this was a great success. And on behalf of Burnished Law Journal, I would like to thank everyone who participated and the judges as well. It would not have been possible without Zaiwalla and Company and UKCA and partners. And on that note, I would like to request Mr. Zaiwalla to speak a few words.
Well, good afternoon to you. It is good morning here from United Kingdom. I'm delighted that you're taking this initiative. And as I say this today, I just want to mention that yesterday, my firm, an Indian origin firm, the first Indian origin, first non-white law firm in the city of London, finished a very interesting trial of a preliminary issue which has got worldwide news, and that is, who is the president of Venezuela? The English court has to decide who is the president of Venezuela, either Mr. Maduro, who is the president at present, or Mr. Guaido, who has been recognized by President Trump in the United Kingdom. And it was a trial which has worldwide news and everybody's interested in it. And I say this because we are today the only Indian origin firm in the 1 square mile business district of City of London. And I was asked years ago that what is the secret that I have survived and no other non-white firm has survived in the white city of London, where when I started in 1978, the solicitors used to wear bowler hat and tailcoat, and to be an Indian was a second-class citizen. And I said that because of my Indianness, I refused to change my name, because when I started, there were a few Indian or Pakistani solicitors firm in the suburbs doing crime, and they adopted English name. Suresh became Sam and all that thing. And I said, no, I kept my Indianness, I kept my surname, I kept my accent, and that is respected. And I think the reason I say this, because the Indian mind is capable of very high thing, but what we lack sometimes is intellectual discipline. And what I would like this debate to achieve, and the Burnished Law Journal to achieve, is to bring in a new sort of innovative approach to the Indian lawyers. And that is that law is for justice and not justice for law. So you have to innovate law to meet the ends of justice. And the most important thing, if you want to succeed, is integrity, honesty with silent courage. And that is true. It is not true that a lawyer has to lie. I refuse to lie. I refuse. If a client comes to me and I find that he's dishonest, I will say no. And I'll give you an example. Last year, we do the international work. We don't do any local work. We've acted for China for many years. We acted for Russia in the UCO's $50 billion. And people come to us for difficult cases, like the Venezuelan sect, a very big law firm, and came to us. And last year we said we were handling the biggest ever claim in the history of United Kingdom for Bank Malad of Iran on nuclear sanctions, which came to me for the Court of Appeal and we won in the Supreme Court, and we won the Supreme Court before 9 bench 5-4, and there was a claim of 1.6 billion damages. And the message I would give is the young team must maintain the legal profession as an honorable profession and not business. And what I have recently found, and I can sharing with because I am an Indian at heart, although I'm a British citizen, is that we must work hard to ensure that the profession remains of high standard of integrity. Because I hear now that there is a lot of standard is falling, and the judges can be brought. I don't know whether it's true or not. So I think the young team must look for the future of India and make India the center. And my goal has always been that this is the first firm people have asked. I've got big firms wanting to buy me off at millions of pounds, and I said no. This is the first multicultural firm, not just for Indians, but any non-white, any from other jurisdictions. And I've said no. It must continue because we are pathfinders. So the young people like you in future can even grow bigger and have the strength and courage that we Indians can meet any challenge from white, Chinese, anything. But most important is please remember integrity, honesty, and that law is for justice and not justice for law. So with that, thank you very much for inviting me. I must congratulate Burnishard Law for the good work they are doing. Now, these are the kind of innovative moves which will ultimately bring forward young Indian. And we want to see young Indian coming and taking over and changing and making India better and better and better. But keep in mind one thing, that we are living in a global world. So therefore, we must keep in mind the principle of one world, one men and women are, in today's model, men and women are equal. That's the most important thing. And what matters is the color of the heart and not the color of the religion, flag, or anything else. So color of the heart is the most important thing. With that, I wish you all the best, Burnish Law Journal, to have more and more events like this, and you have our firm support. Thank you very much. Sorry, I just woke up.
Thank you so much.
Yeah.
Thank you everyone for joining us. Thank you our judges for giving your precious time with us. Thank you to the participants. Thanks to Zaiwalla and Co. and Saroj Zaiwalla sir. And special thanks to our volunteers who work hard for making this event successful. Thank you everyone for joining us. Have a nice day. Thank you.
Thank you.
Thank you for having us. Thank you.
Thank you. Bye-bye.
We'll announce result in WhatsApp group.
Thank you. Bye.
Yes, no as well. Thanks.
All the very best to everybody. Bye-bye.